a tip, and we've got Dylan manning the camera. Say hi, Dylan.
Hi.
Hi. So today we're going to talk about the difference between a power of attorney and a guardianship. So, first of all, what is a power of attorney? Well, if I give somebody my power of attorney, just a regular power of attorney, they can do anything I can do with my signature. So they can sell property, they can buy property, they can borrow money, transfer assets, anything that you can do with your signature if you give a general power of attorney. Now, powers of attorney are usually limited. They're usually set up so that they kick in at a certain point. So like if a doctor says that the person can no longer make their decisions, then the power of attorney can kick in. It can also be limited to, like, let's say you can give somebody a power of attorney just for one transaction, okay? Now, this document is easy. There's a form that you can download. Any lawyer can print it for you, or it's a form created by the statute. It needs to be signed, notarized, some witnesses, and then it's good to go. But when you sign this document, you have to be conscious of what you're doing. So if you've already got somebody who's diagnosed with dementia, or you've already got somebody who's diagnosed with, or they're unconscious, or they don't know who they are or what they're doing, then they're not equipped to sign a power of attorney. So a power of attorney can be very expansive or it can be limited. Now there's also something called a healthcare power of attorney. Healthcare power of attorney is designed so that if you cannot make your healthcare decisions, then somebody else that you designate, your agent, makes them for you. And a doctor has to determine that you cannot make your healthcare decisions, and then the healthcare power of attorney kicks in and you can make their decisions. Now, what's the difference between these and a guardianship? A guardianship is a court order that somebody is guardian over somebody else. And they can either be guardian over the person, so they make all the decisions for that person's body, medical care, where they live, everything. Or they can be guardians of the estate, which means they are guardian over all of their money, or they can be guardian of both. And you can have one person guardian of the money and one person guardian of the person, or you could have the same person, or you could just be guardian of one or the other. You don't have to be both. But this requires a court order. This is a legal proceeding. So somebody has to file against the person to issue a guardianship. The person who's going to be what's called the ward, which is whom the guardianship is going to be over, they get a lawyer, which is called a guardian ad litem. It's just Latin for a lawyer for that person. And then everybody has to go to court. There has to be an affidavit signed by a doctor that the person needs a guardianship. The guardian ad litem, their attorney, has to agree that they need the guardianship. And there's actually a court hearing. And the person who's going to be appointed as the guardian, they have to have not filed bankruptcy, not been investigated by DCFS or social services. They have to qualify to be the guardian. So, if you can, you would rather do this because it's cheaper, it's quicker, and it doesn't require a court order. However, when you do this, the court supervises the guardianship. The guardian is, number one, an officer of the court. Then they owe the court an ethical obligation. If they don't follow what they're supposed to do on court order, they can be prosecuted criminally, and they have to account to the court. Every year, they have to say, this is what I'm doing, and they have an obligation to act affirmatively for the ward. Whereas with a power of attorney, that type of stuff doesn't exist. You don't have to account to anybody as somebody's power of attorney except whomever gives you the power of attorney. And while it's presumed you're going to act in the best interest of the person that gives you the power of attorney, nobody really knows what that means. So if you give somebody your power of attorney and they start selling your assets, that may or may not have been what you wanted. So they're not going to be governed by anybody else. They're not going to be overseen by anybody else. And if they do something that might not be in the best interest of the person who issued the power of attorney, they're not likely to be prosecuted by a court. So this one's more expensive and more time consuming, but it's more secure. This one's quicker and easier, but it can also cause more problems. Now the other thing that can happen is you can have a healthcare power of attorney and the person could be in a nursing home and then all of a sudden say, I no longer give this person my healthcare power of attorney. And even if a doctor has said they cannot make their medical decisions, the nursing home is likely to require you to go get a guardianship. So, powers of attorney, healthcare power of attorney, everybody should have a healthcare power of attorney for themselves. That one is like having a will. You should always have it. In terms of a regular power of attorney, that one, that's your choice. I don't have one of those. I have a healthcare power of attorney and I have a will. If somebody has gotten to the point where they have dementia, they don't know who they are, they don't know where they are, you should be in a guardianship situation. This is not that complicated a lawsuit. It's not that big a deal, but it does take a little bit of time and it does cost a little bit of money. But it is more secure. That's the nice thing about the guardianship is the court oversees that. So that's the difference between all of those things. Dylan, say goodbye.
Bye.
Sideways on Facebook, just so you know.
Oh, really?
Yeah.
I don't know why that happened. I assume we're off, right?